Good afternoon, everybody. Good to see you all again. Roger, thank you very much for the introduction. Good afternoon, everyone, and obviously pleased to be on the stage with my colleague, Minister Nakvi. In my travels as Minister of Municipal Affairs, there's one thing that we can't help but note. Residential construction is booming in many parts of the province. And here in Ottawa, for example, there are 81 sizable buildings in the planning stage. And planning is crucial. The Ontario we build today will determine what kind of communities we'll live in tomorrow and for years to come. We need to do our best to get this right to ensure that our communities are healthy, sustainable, and livable. Since 2003, the government has taken numerous steps in reforming Ontario's land use planning system to achieve these goals. These changes have improved the system, but we want to make it even better. So when I became the Minister of Municipal Affairs, the Premier tasked me with leading a review of the scope and effectiveness of the Ontario Municipal Board with the Attorney General. By engaging municipalities, the public, and interested stakeholders, we were to recommend reforms to improve the OMB's role within the broader land use planning system. Over the past year, my ministry and the Attorney General have conducted this review. And now we're taking another step to further transform the system. On May 30th, I introduced legislation that would, if passed, make transformative changes to improve the land use planning appeal process, including creating a new appeal tribunal to replace the Ontario Municipal Board. That legislation, the Building Better Communities and Conserving Watersheds Act, would, if passed, result in fewer and shorter hearings and a more efficient decision-making process. You'll hear more about the proposed reforms in a few minutes from my colleague, the Attorney General Yasir Naqvi. But let me tell you, as Minister of Municipal Affairs, I'm pleased that the reforms we are proposing would give more deference to municipal decisions. That's what you've asked for, and that's what we've delivered. These proposed changes stem from the ideas put forward in our consultation document and from what we heard during the OMB review. We heard a lot of different views and also some recurring themes. We heard there was a desire for more community involvement, a more meaningful voice in the process, more local control over planning decisions, fewer and shorter hearings, and a more transparent process. We listened, and the reforms we are proposing would give communities a stronger voice in the land use planning process and give more weight to local and provincial decisions. For example, the new tribunal would focus on whether or not a municipal decision is consistent and conforms with provincial and local plans and policies. If the tribunal found the municipal decision is consistent and conforms to provincial and local plans and policies, the municipal decision would be final. If the tribunal found that the municipal decision was inconsistent or did not conform, the matter would be returned to the municipality for reconsideration. We also propose to limit what could be brought before the tribunal. For example, it would not hear appeals on provincial approvals of official plans and major official plan updates, and interim control bylaws for a period of up to 1 year. If passed, these changes would also make the appeals process shorter and less costly by setting deadlines throughout the process. We are also proposing to provide municipalities with more time to make decisions on some matters, giving municipalities more time to consult with the public and more time to negotiate locally developed solutions, and we believe that should help avoid appeals. Taken together, these changes, if passed, could help bring development, including new housing, to market more quickly. And this is central and important. Municipalities would also be able to implement provincial and local policies more quickly, policies that support complete communities and a range of housing types. All Ontarians should be able to count on a land use planning and appeal system that's efficient, transparent, and predictable, one that gives residents and municipalities a say in what is built in their neighborhoods. As local elected officials, you should be the ones to decide how your communities grow and how you meet provincial objectives. Our goal is to support you with our proposed reforms. So far, judging by the response from municipal leaders, I think we've hit the mark. A couple of comments here from a few municipally elected officials that I'll skip through. But we do appreciate very much the positive feedback that we have received. But to be fair, not all the feedback has been positive. There are those who favor the status quo, and in the months ahead, I suspect it won't be all smooth sailing. But our government is committed to overhauling the province's land use appeal system, We are committed to placing more decision-making power in the hands of communities, and we hope we can continue to count on the support of municipal leaders as we move forward. I now give the floor to the Attorney General Yasir Naqvi, who has further details on the proposed reforms. Thank you very much.
Thank you. Thank you very much, Bill, and thank you to AMO for inviting us here today. Good afternoon, everyone. I'm pleased to be here today with my colleague, Bill Morrow, the Minister of Municipal Affairs, to provide an overview of the changes we are proposing to help ensure that Ontario's land use planning system is fair and puts people and communities first. I want to begin by recognizing our municipal partners, all of you, for your hard work and dedication to the communities that you serve. And it's great to see so many of you here today in the city of Ottawa. I hope you are all having a great time in my hometown and spending your hard-earned money in our local economy by supporting our local businesses. So we thank you for that. There are many reasons for me personally to stay here in Ottawa. But one was the prospect of raising my family in a healthy, accessible, and thriving community. And I want this for all families across the province. So I'm here to talk to you about what we are doing to achieve this. As Bill has mentioned, the Local Planning Appeal Tribunal would replace the Ontario Municipal Board to improve our land use planning appeal system so it's more predictable, faster, and accessible for residents, municipalities, and developers alike. This is an exciting change. This tribunal would operate throughout the province as the main adjudicator of Planning Act appeals. It would hear other non-Planning Act matters that are currently heard before the OMB as well. And the changes governing this new tribunal will center around 4 pillars. Number 1, creating greater predictability for residents, communities, and developers. Number 2, giving communities a stronger voice in development. 3, ensuring faster, fairer, and more affordable land use appeals. And lastly, providing access to free legal and planning support for Ontarians. To create greater predictability, these reforms would also keep our cities growing to support the needs of current and future generations, support growth that builds communities, not just bigger cities. And healthy and thriving communities don't just happen by chance, they take careful planning, careful development, and you know that. You all know how much work goes into official plans. There's a massive amount of consultation with the community, developers, resident groups, and approval processes across governments. So it only makes sense that our appeals process shows deference to those plans. That's why the proposed changes would exempt a broad range of major land use planning decisions from appeal, giving communities and developers more predictability. But no matter the level of planning or consultation, we know that there are many different ideas on the best way to develop an area. There are strong opinions and often competing voices. And we know that there will still be appeals. So under the new rules, the tribunal will be mandated to give greater weight to the decisions of local communities, while ensuring that development and growth occurs in a way that is good for the community and the province. This would be achieved by eliminating lengthy and costly de novo hearings for the majority of planning appeals, and by making sure that if the tribunal overturns a municipal decision, and this is key, that the matter is sent back to the municipality for reconsideration, keeping decisions local, right in your community. Though giving municipalities a stronger voice was the central focus of our reforms, during our consultations, we also often heard from people that the appeal process is too long and too complicated. That's why we have proposed establishing transparent timelines at the new tribunal. Residents and municipalities will now have a clear picture of when the tribunal would hear their case and how long the whole process will take. Bill 139 would also promote mediation and the settlement of disputes at the new tribunal through mandatory case management hearings, where opportunities for mediation and settlement could be identified and explored early in the appeal process, resulting in faster and fairer hearings or avoiding the tribunal process altogether. As I said before, we know residents care deeply about the communities they call home. Over the last 2 years, we heard that many residents did not get all the information they felt was needed to participate effectively in the appeal tribunal process. That's why, along with the creation of the Local Planning Appeal Tribunal, we are also planning to create an independent support center to level the playing field. This support would provide free legal and planning information, guidance, and advice throughout the appeal process, including representation to eligible Ontarians. We want to make sure that the voices of Ontarians are heard about the decisions that impact them. I want to assure you that we are committed to implementing changes to Ontario's land use planning system that are fair and put residents and municipalities first. By creating a dispute resolution system instead of the current policy-making body, it is my hope that these changes will help give residents a stronger voice when it comes to land use planning decisions and will restore a balance in the appeal-making process, one that will help municipalities reflect the best interests of the people living in their communities today and for future generations to come. Thank you very much, and now I think we're going to ask Ali and Larni and Kate, whom I'm forgetting her last name right now, Kate Matson-Smith, to come forward to walk you through the details. Thank you. There you are. Sorry about your last name. Yeah.
Good afternoon, everybody. Thank you very much for the opportunity to speak with you today. Just as a quick overview of what to expect, my colleague Ali and I are going to be presenting a detailed overview of the Land Use Planning Appeal System Review and the proposed changes in Bill 139, further to AMO's request to the ministries. I'm going to start with a quick overview of our public consultations. Ali is then going to take you through the proposed new tribunal process, and I'll finish up with the proposed amendments to the Planning Act and how, if passed, municipalities will have greater control of land use planning at the local level. So starting with the consultations. The changes proposed in Bill 139 are the accumulation of the review of the OMB and the Land Use Planning Appeal System that started back in the spring of 2016. The review focused on both the scope of matters that are adjudicated by the OMB, as well as the effectiveness of the OMB. And in the fall of 2016, the government released a consultation document that included a range of public reforms for comment by municipalities and other stakeholders. Through the consultations, we received more than 1,100 written submissions, and more than 700 people participated in town halls that were held all across Ontario. I think that is just reloading, sorry. Great. At all of the town halls, it quickly became evident that there was strong support for the review of the OMB. Even supporters of the OMB thought that improvements could be made. Many people said that too many land use planning decisions are being appealed, and as a result, there are too many long delays and costly hearings. We also frequently heard, although not from all sectors, that there should be more respect for municipal decisions. Individuals and groups told us that it's far too difficult for residents and community groups to participate in the process. We asked more questions, and we found that community groups feel that they don't have the knowledge or the resources to participate effectively at the OMB. Many also said that the OMB process has become extremely intimidating and that hearings go on for far too long. There was a real desire to tone down the adversarial nature of the process, and mediation was often suggested as a way to accomplish this. Every sector saw support for mediation. I'll now turn things over to Ali for a couple of minutes to talk about the changes to the OMB processes.
Thank you, Kate, and good afternoon. I will now take you through the highlights of some of the key reforms that we are proposing in response to what we heard during the consultation process. You heard from Minister Morrow and Attorney General that if passed, the proposed legislation would improve Ontario's land use planning appeal system. And I'm going to take you through some of the key elements of that. First, the Ontario Municipal Board will be replaced with the Local Planning Appeal Tribunal, which we are going to be referring simply as Tribunal during this presentation. Second, there would also be a new independent agency, and this is outside the current Ontario Municipal Board, which is called Local Planning Appeal Support Center. This center is to assist Ontarians with understanding and being able to actively participate in the appeal process. I will be providing a little bit more information about this as we go through. Third, consistent with what we heard that there should be more respect for municipal decision, we propose to limit the tribunal's ability to overturn municipal decisions. The proposed changes to the Planning Act would limit the tribunal's ability to overturn municipal decisions and protect major planning decisions from appeal. And later on, Kate will be explaining this a little bit more in detail. With respect to hearing process, we want to assure everyone that we have heard the feedback regarding the hearing process at the OMB. So we are not just talking about proposing a name change and also talking about jurisdiction. Proposed changes will also improve the hearing process. I'm now going to explain how the legislation, if passed, would improve the appeal hearing process at the new tribunal to be faster, fairer, and more accessible. First, if the legislation passes, an early process improvement would be the new mandatory case management conference. The tribunal would be required to hold one for all major land use planning appeals prior to holding a hearing. As a mandatory first step, the case management conference would allow the tribunal and parties to identify and narrow issues and discuss settlement opportunities, including mediation. We understand that there is general support for mediation from the municipalities, and that is why our proposed changes would promote mediation in this process. We will also be introducing timelines for hearing and pre-hearings at the tribunal. At the case management conference stage, parties' submission would have to be made to the tribunal at least 30 days before the date of the conference. I want to add that there would be hearing timelines set out in the regulation. So all parties to an appeal would benefit from transparency and predictability of the process. We are still considering these timelines, but our proposed timelines will be posted in advance for public feedback on Ontario's regulatory registry. So you will have an opportunity to provide feedback on that element. However, let me assure you that we have certainly heard concerns about OMB's hearings taking long time. If there needs to be an oral hearing, there would be time limitations on oral presentations at such hearings. Another changes we are introducing is reducing the adversarial nature of the hearings. We propose there be no examination or cross-examination of witnesses in major land use planning appeals at the tribunal. Also, the proposed legislation clarifies the tribunal's power to more actively guide the hearing, including explaining procedures, asking questions, examining a party, or requiring a party to produce evidence. These proposed changes would result in faster, fairer, and less adversarial hearings. I'm now going to briefly walk you through how a typical major land use planning appeal would be dealt with by the tribunal. This will show the proposed improvements in action. Generally speaking, the proposed new hearing process would work as follows. So the process begins with the tribunal receiving record of a municipal decision. Following notice of appeal, the matter would proceed to mandatory case management conference where opportunities for mediation would be discussed. Any issues identified for mediation would proceed through the mediation process. If there are issues that could not be settled at mediation, the next step would be a hearing. If the matter proceeds to an oral hearing, aspects of hearings related to the production of evidence and oral testimony would be subject to rules and timelines set out in the regulation. So this is different than the current process at the Ontario Municipal Board, where there is more flexibility given to parties to determine what evidence to submit, how and when oral testimony is going to be presented, and the length of time assigned to the individual participants. Finally, the tribunal would determine whether the municipal decision is consistent with and conforms to provincial and local plans. And this is key that Attorney General and then the Minister indicated. Kate will be providing more details on this one and next steps later on. While these reforms address the hearing process, there are additional ways that the legislation would help Ontarians better understand and participate in the tribunal process. The proposed local planning appeal support center would assist Ontarians at hearings by providing general information about land use planning, guidance to residents on the tribunal processes, and providing legal and planning advice at various stages of the process, including where they are eligible legal representation. The tribunal would also develop user-friendly tools, including a new website, and also support center will do the same, to have enhanced information and include such videos related to hearing process so that people better understand the process. The tribunal would also provide easier access to tribunal decisions through public posting and plain language summaries. So those are just highlights of some of the elements that you will see in terms of the tribunal process. Now I will ask Kate to return to the podium and continue with the presentation. Thank you.
Thanks, Hallie. So I'll talk for a few minutes now about proposed changes to the Planning Act that will limit what can be appealed. In many jurisdictions, when the province or the senior level of government approves major planning documents, such as official plans, those decisions are not appealable. As noted by Minister Morrow, we propose the same sort of approach in Ontario for official plans and official plan updates that are approved by the Minister of Municipal Affairs. This would include conformity exercises in which municipalities are bringing their official plans into alignment with provincial plans, such as the growth plan for the GGH. The intent is to help both municipalities and the province to further protect both provincial and local issues. And it will mean that the province and municipalities have to work very cooperatively in the early part of the official plan update process in order to ensure that both local and provincial matters are adequately addressed. The Ministry of Municipal Affairs is looking at ways to ensure our decision-making is more transparent. Our goal is to place a greater emphasis at the front end of the official plan review process, leading to a more streamlined and efficient approval by the ministry at the end of that process. Lastly, we're proposing a reform regarding minister's zoning orders. As you know, MZOs, which they're often called, are used very sparingly, usually to facilitate an economic development opportunity, such as an auto plant or to protect an environmental feature. We propose to remove the mandatory referral of minister's zoning orders to the new tribunal. The minister would make the final decision on requests to amend or revoke an order. As you know, the Planning Act outlines municipalities' authorities related to land use planning. We propose to reinforce that authority by reducing the ability of the tribunal to overturn municipal decisions. The proposed tribunal's jurisdiction would be limited to whether or not a municipal decision is inconsistent or does not conform with either a provincial or local plans for some planning matters. The proposed change is intended to result in fewer decisions being brought before the new tribunal and to give more weight to the decisions that are made by municipal officials elected locally by the public. Under the proposed bill, a municipal decision would stand unless it was demonstrated that that decision was somehow contrary to local or provincial planning policies or documents. This type of standard would apply to the adoption or approval of official plans, zoning bylaws, as well as community planning permit systems. It would also apply to the refusal or non-decision on requests to amend official plans, zoning bylaws, and community planning permit systems. Inconsistent or non-conforming decisions would be sent back to the municipality for the municipality to then make a new decision. The municipality would generally have 90 days to make a new decision. If that second municipal decision would be final unless it is appealed. If that second decision is appealed, the tribunal would hear the matter again and look to see whether it is now aligned with local and provincial policies. If it does align, the second municipal decision stands. But if the proposed tribunal finds the second municipal decision is again inconsistent or non-conforming, the tribunal would then make the final decision. To support greater municipal control over local planning, we're proposing a new discretionary tool designed to allow municipalities to designate and zone what will be called protected major transit station areas. When the municipality designates these areas, there would be no appeal of either official plan provisions that provide these densities and heights, and once designated, the municipality would zone for density and height requirements designed to support transit service, and there would be only limited appeal opportunities to appeal the zoning requirements. Zoning would need to conform with the provisions and standards that are set out in the municipality's official plan, and this will help to provide certainty for communities. I'll emphasize here that this would be a discretionary tool for municipalities to decide if they wish to use it. And it would support investment that is being made at all levels of government in public transit infrastructure, which is especially important at this time. Continuing with our theme of giving municipalities more control over local planning, I want to talk for a moment about what we propose for secondary or neighborhood plans. For years, we've heard from municipal officials that no sooner do they have a new secondary plan in place that they receive applications to make changes to it. Not only does this detract from proper implementation of the policies, but it diverts municipal staff from undertaking other planning work. The government proposes that no amendments would be allowed to secondary plans for the first 2 years unless allowed by the council. As a best practice, with the people with an interest in the area covered by a secondary plan should, wherever possible, be involved upfront when a municipality is preparing a secondary plan, rather than relying on the amendment process after the fact. The province also proposes to limit appeal of interim control bylaws. As municipal councils, you pass these bylaws to put a pause on development, to take time to undertake studies of particular areas or particular issues. The government proposes that there would be no appeal of municipal interim control bylaws when first passed for a period of up to 1 year. This would enable you to get on with the studies you need to do rather than preparing to defend them at the board. The next proposed change concerns local appeal bodies. Municipalities have the ability to establish local bodies that can adjudicate certain planning matters rather than having them referred to the OMB. Currently, these local appeal bodies can deal only with minor variances and consents. Through the legislation, the government proposes to broaden that to include site plan matters as well. To allow municipalities to exercise their greater decision-making authority and to consult with the public, the province will extend the timeframes in which municipalities and approval authorities must make decisions on certain planning matters. Currently, municipalities and approval authorities must make decisions on planning applications involving OPs within 180 days and zoning bylaws within 120 days. Otherwise, the lack of a decision can be appealed to the OMB. The government proposes through the legislation to increase each of these time periods by 30 days to give more opportunity to work issues out locally and avoid disputes going to the proposed tribunal. And I think we can all agree that settling matters locally is in everyone's best interest. Ali and the ministers and I have presented a lot of information to you today, and like all proposed legislation, you can find the full text of the bill on the Legislative Assembly website, and you can also find a summary on the website of the Ministry of Municipal Affairs. The bill has received first reading, as was noted earlier, and I'd encourage you to provide comments at your earliest opportunity. We now, I understand, have just a brief period of time for some questions, so I'd invite the ministers to return to the stage and pass the podium back to Chair Anderson for the Q&A.
I used to get more information.
Oh, now it's working. Thank you very much, ladies and gentlemen. We have, because the government was so efficient, instead of 9 minutes of questions, we have 3. So, wasn't you two. Your two are okay.
Thank you.
So we'll take questions, but please just state your name and your question without a lot of theory behind it. And we'll start at microphone number 1.
I'm just the mic stand, Roger.
Oh, you're the mic. Then
Yeah.
we don't want to talk to you.
Roger, number 3.
Mic stand number 3.
this on?
Yes.
Thank you. Thank you so much for the review of the OMB. My name is Yvonne Fernandez. I am a city council for the city of Kitchener. I am part of the steering committee that worked so hard to bring Ontario Summit to the Aurora area, and we were very happy to see the changes that you're making. My one quick question is, how will it be decided who will be sitting on the local tribunals?
Okay, thank you. So I'll take that question. So we have as you know, we have a process to appoint members to currently Ontario Municipal Board, and then when the new tribunal that will be created, Local Planning Appeal Tribunal, we look for various skill sets and competencies in making those decisions. Of course, planning law and planning act experience is very important. So we will continue with that process to make sure that we have the right kind of people sitting on the tribunal. One of the important things I think we have to remember is that we're really significantly changing the culture of the way planning appeals will be done. So part of that work is going to make sure that the kind of people we appoint to the tribunal conform to that culture, where the focus is more in making good planning decisions early on the process at the municipal level, and really sort of applying the legal test that has been outlined, which is looking at whether a decision is consistent or conforms with the planning documents. We're also going to be bringing forward training for our existing members and new members to the new legislation, so that they are fully aware as to what that new legal analysis will look like once the legislation is passed.
Thank you very much. Microphone number 4.
Good afternoon. Sue Foxton, Regional Councillor, North Dumfries, Regional Councillor, Waterloo, and Mayor of North Dumfries. 2 questions. The first one is, you're providing free legal and planning to people that wish to appeal. Who pays for it? And the second one is, I'm on TAPMO, the Top Aggregating Producing Municipalities of Ontario. There is a lot of opposition to gravel. With the free legal advice and planning, have you opened the door to a lot more of this?
So I think it's really important to know the reason behind creating a local planning and appeal support center. The proposal as we put forward. During our consultations, we heard very loud and clear from communities that they felt that they don't have the right set of information when it comes to how their communities are developed. And when it came to the current OMB process, a lot of the local community residents associations, peers group, they just lost in the process. And it felt, we felt very strongly that we need to have supports in place to empower local communities in order to do so. So to answer your first question, who pays for it? The province will pay for it. It's something that will be covered through my ministry of the Attorney General. To second question, it's not going to be available to everyone. The center is going to create eligibility requirements. So there is going to be some sort of a threshold that is going to be used as to who can qualify, whether they just get information and advice in terms of how the process works, or actually get legal or planning representation. We're going to flesh out those rules, and there will be checks and balances as to who gets supports and how. The last point I will make quickly, I think that we have a good model in place to look upon, and that is the Human Rights Legal Support Center that we created some years ago on human rights matter. That support center has worked well, so we're sort of looking at that for guidance as to how this support center and planning issues could be constructed on.
Last question, microphone number 2.
Yes, Alan Thompson, Mayor of Caledon. My question is, really, here's the situation. It's lawyers, and developers have really good ones. The question is, what would happen if the developers decide to go on procedural fairness because they don't feel they have their time at council, the way our procedures are structured, that they just don't go to court and bypass the tribunal? And that would take up a lot of time. Has that been considered?
Both do it, okay?
Again, those type of options are always available, still available today. You know, you can go to Superior Court, for example, and judicially seek judicial review of a decision based on procedural fairness, and that's a right, that's a constitutional right that exists in our system that no legislation or no legislature will ever take away. So it's no different than what you're proposing, what exists today. So it will be incumbent upon you as decision makers to follow the right process, to make sure that there is due process and there is a fair process, so that parties are included. I mean, all these changes will also mean all of you looking at your decision-making processes to make sure that it is robust, and that developers and communities have the right set of opportunities in the process, as sort of the changes that were made through Bill 73 in the Planning Act, to engage them before you make the decision around development.
And Alan, I would just add that we're just sort of turning it on its ear a little bit, right? So that rather than the stakeholder group or other groups that you're referencing are doing their work on the back end of the system, they're going to have to do their work on the front end of the system now. We all know in this room the length of time and the consultation that goes into developing OPs, and so that work is going to happen on the front end. It's not going to happen on the back end. So to address your question, I still think there's going to be plenty of time for people to make proper representation of the interests or the matters of interest to them as individual stakeholder groups. OPs take a very long time. The work's going to happen on the front end, or should happen on the front end now, rather than on the back end, after a province has already approved an official plan that a municipality has taken years to develop.
Ministers, thank you very much for appearing here today. It's much appreciated. Just so you both know, this is all being audioed and taped, and we heard you say